Good afternoon, everybody. Thank you for joining us this afternoon and talking about one of my absolute favorite subjects, the Freedom of Information Act. My name is Kevin Barnett, and I'm counsel here at Polaro Mazza. I handle the full panoply of government contracts issues, from bid protests to claims. I also do quite a bit of work with the Freedom of Information Act, which is our topic today. I help draft requests, pursue requests, I help protect from information being released, and I've litigated a number of requests in federal court. At Polaro Mazza, we do a lot of the same thing. We're a full-service strategic partner to government contractors, but we also do a whole lot more. Offer that same strategic advice to businesses, and we have a full corporate group. But today we are not talking about the numerous things that the firm does that well. We're here to talk about the Freedom of Information Act. Shortly, I'm going to give you a quick overview of FOIA. I'm then going to go through the submitter notification process. That's when agencies let companies know that their information may be disclosed. Then I'm going to talk about Exemption 4. Exemption 4 is the FOIA exemption that allows companies to request that their confidential information be withheld. And that has gone under, significant changes over the past, 5 years. And then we're going to end it with best practices for companies to protect their confidential information. So the Freedom of Information Act is a very impressive law that allows just about anybody to request records from the executive branch. And there are also state and local versions. Every state has a version. They come under a few different names. Sometimes they're called right to know laws or sunshine laws or public record laws. But they all basically allow the same thing, and that is for the public to gain access to government records. But the purpose of this law, as the Supreme Court said, is to essentially allow citizens to know what their government is up to. And for this reason, FOIA is interpreted very broadly. It's always interpreted in favor of disclosure. So that's an important point to keep in mind. Slide. So when there's a FOIA request, there are essentially three parties. There's the requester, that's the person submitting the request. And in this case, person is defined very broadly. That could be corporations, that could be associations, that could even be non-citizens. There are a number of ways that the requester can remain anonymous. There are third-party requester services that will submit requests on your behalf. Or a lot of times people will come to us at the law firm and we'll submit a request without naming who the ultimate party is. The second party involved is the agency. Now, it has to be an agency of the executive branch. So that doesn't mean, so it does not apply to the White House, does not apply to Congress, does not apply to the courts, does not apply to state and local agencies, although most of those institutions have some type of mechanism for transparency. Finally, the third party is the submitter. The submitter is the person or company that provided information to the government that is now being requested. And whenever information that is provided by a third party is designated as confidential or reasonably appears to be confidential, that person is considered a submitter. And if that information is requested, it triggers the submitter notice process. Next slide. So under FOIA, what can be disclosed? The statutory term is records, and records is a very broad term. It can include paper records, emails, electronic documents. However, it does not, what what a record is not. It's not something that's never existed or something that could be created. You cannot use a FOIA request to make the government create a document. It doesn't include records that have been lost or destroyed. Again, it's really only records that are in the agency's current possession. Also, under FOIA, there are what's known as exclusions, which are documents that don't have to be disclosed, and those generally have to do with national security or the intelligence agencies. And then more commonly, there are 9 exemptions. And those exemptions, if a record or a portion of a record falls within those exemptions, the agency can withhold it as well. Next slide. However, if an agency does want to withhold information based on one of the FOIA exemptions, the agency bears the burden to show that it falls within one of the 9 enumerated exemptions. And as we're going to talk about later, in 2016, Congress added an additional requirement that the agency must also show that disclosing the record would reasonably foresee that disclosure would harm an interest protected by the exemption, or that disclosure is prohibited by law. In addition, just because one small part of a document is covered by an exemption does not mean the agency can withhold the entire document. To the contrary, the agency has an affirmative obligation to release reasonably segregable portions. Courts have generally, interpreted that as distinct parts or maybe distinct paragraphs. If the protected information is so intertwined with the other information that it wouldn't be meaningful to release the other information, then the agency can withhold it. Here's just a high level summary of the 9 exemptions. Classified information is exemption 1. Exemption 2 is documents relating to the internal personnel rules and practices. A lot of times like the internal telephone directory, things like that. 3 is exempt by other statutes. 4 is the most important for our conversation today. That exempts trade secrets and commercial or financial information obtained from a person and privileged or confidential. 5 are the traditional litigation privileges: attorney-client privilege, attorney work product, deliberative process privilege, which is a favorite exemption of the government. Presidential communication privilege is a hot topic these days. That would fall under exemption 5. Exemption 6 is also an exemption that contractors often invoke. It protects information, the release of which would be a clearly unwarranted invasion of personal privacy. Exemption 7 deals with records compiled for law enforcement purposes. Exemption 8 is records related to the oversight of banks. And exemption 9 is geological and geophysical information and data, including maps concerning wells. I have litigated or addressed every single one of these exemptions in some form except for number 9. So that's still my white whale out there. I need to make more geological FOIA requests to check that box and win FOIA bingo. But one of these days. So as I mentioned, if a company has provided information to an agency and that information is designated as confidential or reasonably appears confidential, if the agency wants to disclose that, it triggers the submitter notification process. This process is outlined in an executive order. It basically, the agency identifies the information, the submitter designates the information as confidential. The agency gets a request for the information. The agency notifies the submitter, and that can be done in one of 2 ways. Notice can be provided by a letter, which is the traditional way, saying we've got this request and please review these 5 documents and let us know what information here you consider confidential and please provide the supporting information. And then the submitter will respond with that supporting information and the agency will then respond to the request. 9 times out of 10, when the submitter responds, they never hear back and the agency just adopts their recommended redactions. Sometimes the agency will ask additional questions. Sometimes the agency will come back and say, we disagree with you, we're gonna release this information anyway. Next slide. Every agency has essentially submitter notification regulations. I've included a number of them here for your reference. These basically will tell you what the agency considers to be confidential information. Some of them will go so far as to say that the agency will not release confidential information. Other 8 will say that they will only release it in accordance with the Freedom of Information Act. This also gives you your timelines for how long you have to respond to a submitter notification letter, what rights you have if they reject your interpretation, if they have to provide you notice, and how much notice they need to provide you so that you could potentially pursue a legal action to prevent them from releasing it. As I mentioned, this is all kicked off by the submitter notification letter. I think many of us on this call have seen those. Sometimes, however, it can be kicked off by a Federal Register notice. And that's actually what happened last month. The Department of Labor issued a notice saying that it was considering releasing 15,000 contractors' EEO-1 reports in response to a FOIA request and gave everyone a month to respond with any objections. That's the process that's often used when there's a large number of relevant submitters. I mean, it kind of stinks, but it's understandable why the agency might need to send out just one Federal Register notice as opposed to 15,000 individual company letters. The submitter notification letter will often, but not always, attach the records at issue. If you do get a letter that does not attach the records, I always ask the FOIA officer if they'll provide them. I just like to all be working off the same sheet of music so that I know what documents they're considering are up for release. And I don't give them any ideas of additional documents they can release if I go digging through my own files. The letters also include a deadline for responding. Many agency regulations say this needs to be at least 10 working days. I found that regardless of what the regulations say and regardless of how short a time frame the letter provides, the FOIA officers are usually just happy to have a dialogue with someone and are very, very generous with granting at least the first extension. I've really never had a problem getting a week or 2 additional time to respond. These notifications will sometimes include a copy of the request and sometimes will include the name of the requester. Remember, the name of the requester is not confidential. It is public information, although sometimes agencies may not always reveal it or may not volunteer that information. When responding to one of these letters, there are a few best practices. I always put a restrictive legend on there, letting them know that my response itself is confidential information. And I also like to confirm the scope of the request, repeat back exactly what the agency told me, or catalog the documents that the agency provided. I would say the agency is considering releasing 4 documents: contract number 12345, attachment B to that contract, modification 01, modification 02. Again, just so there's a record of what I'm reviewing and what I am saying I'm okay with releasing and what I'm objecting to. I always flag, these submitter notification requests ask about Exemption 4. So I'm always certain to flag any information that I think is company confidential. At the same time, I am not shy about flagging other possible exemptions. Exemption 6, if there are personal email addresses or phone numbers or people's signatures, that information just doesn't need to be out in the public domain. There's certain, the exemption 3 covers sometimes proposal information or certain information that could be considered military, technical, or national security information. So I'd flag that as well. Put these bugs in the ear of the contracting officer. It might not be the company's right to assert those additional exemptions, but if you put together a good argument for why they apply, the contracting officer or the FOIA officer will usually go along with you. Also in this letter, it's really important to provide legal and evidentiary support for the confidential designation. And you need to really hit every element of the confidential definition, the foreseeable harm, etc. You can attach declarations from knowledgeable persons, although that's usually not necessary. But it's important to be as specific as possible. It just makes for a more robust and convincing argument instead of saying, just our company doesn't release this information, to talk about how the company has, its corporate confidential information policy that's been updated, 3 times in the last 4 years. All employees sign a non-disclosure agreement, and the 13 employees who have access to this information sign an additional non-disclosure agreement. It just makes, like I said, for a more robust argument. I also attach copies of the documents, and I do attach 2 versions. I put together the version with the proposed redactions highlighted, and I also try and make their job easy for them, and I put together a completely redacted version that I think is ready to go, ready for public release. And then I always end the letter with requesting an opportunity for to clarify or provide additional information. I will note that I have had FOIA officers come back to me numerous times asking for clarification or more information, but the FOIA regulations generally do not provide a requirement for them to do so. So do make sure that your initial response is as robust and complete as possible. After you make that submission, the agency is required to, quote, give careful consideration to all of the grounds identified. If the agency disagrees, they can provide a written number of, they need to provide a written statement explaining why, and allow a reasonable number of days before they're going to disclose. And that reasonable number of days gives the gives the submitter an opportunity to file what's called a reverse FOIA lawsuit and, take the issue to court, seeking an injunction preventing the agency from withholding the information, from releasing the information rather. In addition, if the requester files a lawsuit, the agency is supposed to give you prompt notification. So that's after the agency says, no, we're going to withhold this information. If the requester then takes it to federal court to challenge that decision, they have to let you know. So as I mentioned briefly, you get the notice if the agency disagrees with you, so that the submitter can file a reverse FOIA action. This is governed by the deferential APA Administrative Procedure Act standard, which requires you to show that the agency's decision to release the information is arbitrary or capricious or otherwise prohibited by law. On the other hand, if the agency agrees with you and then the requester takes the matter to court, the submitter is not a party to that action. It would be captioned requester versus agency. But the requester would have the option to intervene in the lawsuit, or merely support the government in a background kind of role. I will say that the government, at a minimum, is going to need a declaration from the company explaining what steps it took to keep the information confidential. In some situations, the intervention can actually be a trade association. So in the case we're about to talk about in a few minutes, the Supreme Court case that kind of turned Exemption 4 on its head, the parties, it wasn't the individual stores whose information was going to be turned over. It was a trade association that brought the lawsuit or was party to the lawsuit challenging the release. I know a lot of companies hesitate to intervene in these types of actions. There was a lawsuit a few years ago where a company was seeking, very much like the EEO request that is kind of up in the air right now. The same requester, Center for Investigative Reporting, filed a FOIA request for a number of technology companies' EEO-1 reports, and Department of Labor would not release them. They were taken to court over that decision, and in federal court, the judge ultimately sided with the agency. I'm sorry, ultimately sided with the requester and released that information. And after they did so, there was a company that was very upset that they didn't get, they felt they didn't get to explain their position, and tried to intervene after the decisions had already been made. And were told that they were too late. So I kind of call that non-intervener's remorse. In rare cases, however, it's not, intervening does put somewhat of a target on your back, because some courts have allowed for discovery into a company's practices. That would be when there is confusion over the declarations that have been issued. Hold on, we got a couple questions that I wanted to answer. All right, and first question is, since you mentioned it, what are your thoughts on the FOIA request to DOL for the EEO-1 data? Should contractors object, and if so, how? I think that if you keep your EEO-1 data confidential, then you should object. The difficulty is that there was that prior court case where the court said that information was not commercial. I don't think that was a very well-reasoned opinion. I do think that information about the number of employees is commercial information. I think companies have a commercial interest in it. I think there's a potential competitive harm to that type of information being released. So if you are in the boat where you do take pains to keep that information confidential, I do think you should object. We can help you. We've helped a number of clients file letters outlining the objections and outlining why and how they keep that information confidential. However, there are a lot of companies that champion their diversity efforts, and they release that information and they publicize it, in which case you don't really have standing to object. And so I wouldn't waste your time. In fact, that was one of the criticisms in the earlier case, is some of these companies mentioned that they guard this information and don't release it to anyone. And the other side pointed out, well, you've actually trumpeted very similar information in your annual reports and in your press releases, talking about how, you know, your progress in creating a more diverse environment. If you did not receive a letter, you know, somebody asked the question, if I did not receive a letter, do I need to respond to this? If yes, where should I send my email with our company's response? I presume that means if you did not receive a letter about the Department of Labor's EEO1 FOIA request, do you need to respond? No one received a letter. The Department of Labor, as I mentioned earlier, did not send out a letter informing companies that their information was going to be disclosed. Instead, because there were 15,000 or so contractors whose information was at issue, they posted a notice in the Federal Register. So if you provided Department of Labor with if you filed EEO1 consolidated type 2 reports from 2016 to 2020, your information is being considered to be released in response to this latest FOIA request. And if you don't object, your information will be released. All right, next question. Next slide. So we've talked a little bit about the process, and I've alluded to Exemption 4, which I think we've all heard of or discussed. The actual statutory language is that Exemption 4 protects trade secrets and commercial or financial information obtained from a person and privileged or confidential. So let's break that down on the next slide. So what it protects is two different things. It protects trade secrets, and trade secrets are a very narrowly defined category of information. Generally, it's something that the company keeps confidential, and the confidentiality of that information is competitively significant. Examples of trade secrets, you know, Coca-Cola's secret formula. That's a trade secret. It's very difficult to establish that information, you know, rises to the level of trade secrets. So most of the time when we're talking about Exemption 4, what we're talking about are commercial or financial information obtained from a person and privileged or confidential. And that breaks down into three different elements. Commercial or financial information, 1, obtained from a person, 2, and privileged or confidential, 3. 9 times out of 10, go back, hold on, we're not, 9 times out of 10, commercial or financial information is fairly obvious. Contracts, financial statements, invoices, those are commercial or financial information. Obtained from a person is also often an easy box to check. Corporations are considered persons, and so if a company provided documents to the government, then those documents were obtained from a person. Where the rubber meets the road on these disputes is typically in the question of whether it's privileged or confidential, and really focusing on confidential. Next slide. Historically, confidential was determined based on whether the information was voluntarily disclosed to the government or involuntarily disclosed. So if it was involuntarily disclosed, confidential meant if the public disclosure of the information poses the likelihood of substantial competitive harm, from national parks in 1974. The DC Circuit took that in 1992 and raised some questions about it, saying, well, I think national parks only applies to mandatory submissions, For involuntary submissions, or for voluntary submissions rather, the confidential would mean customarily not released to the public by the person to whom it was obtained. And that dichotomy governed Exemption 4 confidentiality from the 1970s all the way through 2019. In 2019, the Supreme Court issued a decision, Argus Leader versus Food Marketing Institute. At issue in that case were food stamp redemption totals for each store. This information is tracked by the USDA, and the stores themselves thought that they were providing it with assurances of confidentiality. A newspaper, the Argus Leader in North Dakota, filed a FOIA request asking the USDA for the annual redemption data on a store-by-store level. The trial court, although most FOIA lawsuits are resolved on the papers, they're resolved on summary judgment. The trial court couldn't make a decision on summary judgment and actually had a trial. After the trial, the court said that the stores didn't establish that releasing this data would cause substantial competitive harm. They established a little competitive harm, but not substantial. The Trade Association Food Marketing Institute intervened and appealed, but the 8th Circuit affirmed the trial court decision, and that teed it up for the Supreme Court. The Supreme Court looked at the case and said that this competitive harm test has no basis in the statutory language, and said that confidential for the purpose going forward, we're going to look to the dictionary, which means it was customarily kept private or at least closely held by the person imparting it, and if the party receiving it provides some assurances that it would remain secret. So that's the new definition of confidential. Which now essentially has 2 prongs. Like I said, there's the kept private prong, and the court looked at this and said the retailers customarily do not release this store level data, and even within the companies themselves, only a small group of employees had access to it. They also said that the stores met the assurances of confidentiality prong because there were regulations that limited the disclosure of the information. And in some years, there's actually a criminal offense to release the information. However, as if changing 50 years of jurisprudence wasn't confusing enough, the Supreme Court comes in at the end and says the first prong definitely applies all the time. We're not sure if the second condition about government assurances is required. We're not going to reach that now because there's no need to. So we'll leave that as an open question. So that was in 2019, which has resulted in a drastically changed FOIA Exemption 4 landscape. Finally, here we are in 2022, and a number of district courts have had a chance to opine on what this means, but there are still a lot of open questions. First, and I think as a practical matter, most important, what does a company need to show to prove that it meets the new tests? Which begs the question, are there 1 test for confidential, or now are there 2 tests? Is it 1 prong or 2? Supreme Court left that open. And then, does competitive harm still matter? I know the court said national parks was dead and that no longer defines confidential, but that holding of competitive harm was essential for reverse FOIA lawsuits. It's also potentially implicated by the new FOIA Improvement Act of 2016, that foreseeable harm standard. You know, what is the harm from exemption that is protected by Exemption 4? So first, let's tackle, what does a company need to show? What does actually and customarily kept private means? First, you know, for an agency to show this, they need personal information, and that usually means support or an affidavit from the company. Actually and customarily kept private, that's a company by company determination. It's not an industry-wide standard. So there will be situations, and I think these EEO1 reports are a great example, where some companies keep them private and some companies make them public. In good news for, you know, most government contractors, the general consensus is that the new actually and customarily kept private standard is a much easier test to meet than the competitive harm standard. You know, it's been described as significantly less demanding. Another court said that requesters challenging Exemption 4 face a steep uphill battle under the new standard. So that's encouraging. Here are some examples of exactly what companies need to show. Confidential treatment. How are they treated? Need to know access. So showing that it's a limited pool of employees who have access to this information. You know, password protected files. Only certain people have the credentials that can get into this file, into this network, etc. Periodic training on confidential information. Making employees or consultants sign NDAs. The markings on documents have been found to be particularly important. One court said that since the company had a privacy officer whose job was to supervise the protection of confidential information was a helpful fact. Requesting confidential treatment using the agency's regulations is another often overlooked piece of the puzzle. However, the court's been clear, like, you don't need to do all of these things. It's that you display, you know, just a few of them as indicia that you keep the information confidential. Likewise, there are a few things that are red flags that may indicate you do not keep the information confidential. Most obviously, prior disclosure. If you've released this information before, or even if you've released this type of information before, it's tough to argue that you customarily keep it private. There's also been some cases where wide distribution within the company has been fatal to a claim of confidentiality, or that the company takes no steps to prevent disclosure by employees or suppliers. Courts have also applied the prior, particularly in the District Court of DC, where most FOIA requests are litigated. They've helpfully applied the critical mass standard. Now, critical mass, if you recall from a few slides ago, is the 1992 case that said for voluntarily submitted information, all you have to do is show that the company kept the information confidential. The courts have looked at that and said, oh, well, the new standard is essentially the critical mass standard, so we're going to continue to apply the same standard. So that gives us a much wider swath of case law to apply. Next slide. The Department of Justice also issued guidance in response to Food Marketing Institute, and their guidance was very high level. It was among the first piece of information, but it basically says an agency's knowledge of the information, the submitter's practices, or from the records themselves. Again, if there are markings, what the agency was told. Next slide. Courts have also come to a general consensus about that elephant in the room open question that the Supreme Court left us with, one prong or two. Although most cases have sidestepped the issue, saying we're not going to decide if it's necessary because it's here, it's present in this case. or confidentiality failed for a different reason. Most courts have, in DDC, they have been very clear that the second prong is not mandatory. Government assurances of confidentiality are not mandatory. Again, applying that DC Circuit precedent of critical mass. That said, they are quick to note that while it might not be necessary, it's certainly relevant to the determination. And in a lot of ways, courts have looked at that and said, if an agency told you they're going to release the information before you gave it to them, then that's almost a game. That's almost game over. Similarly, the Southern District of New York has issued a couple opinions where they've noted that the assurances of confidentiality are not mandatory, but they are relevant. In sharp contrast, there's a Northern District of California decision that says the assurances of confidentiality are mandatory, and they're applying old Ninth Circuit precedent from the 60s, GSA v. Benson. So it is in everyone's best interest to, whenever asserting Exemption 4 applies, to not only note how the company actually and customarily keeps it private, but also explaining the types of assurances of confidentiality that the company has. And there are a lot of very, very standard ways to do this. If there are statements on a form, that information will not be released. If you submitted a document with restrictive markings and the agency did not question those markings. Agency policy or regulations, again, those agency regulations that I had on the slides earlier, a lot of them indicate that they will not release confidential information. Agencies have also gotten away at a court by just saying they understood industry practice, and that was the assurance of confidentiality. Very helpful if the information was disclosed as part of a settlement agreement or some other stipulation that included a non-disclosure provision. And you can also have assurances based on, a history of withholding the information. Oh, this agency has withheld this information year over year over year, and now they're changing course. Well, we had that understanding that they were gonna. On the opposite side, there are no assurances of confidentiality. This seems a little obvious when there are explicit statements that it will be disclosed, or the agency has a history of releasing that information, or the agency is legally required to release the information, or even when the company is legally required to release that information to its employees without restriction. DOJ, again, early after the Supreme Court came out with this decision, filled the void and issued this guidance. They said that the interpretation of confidential, these assurances of confidentiality, there was another Supreme Court case, Department of Justice v. Landau, that interpreted Exemption 7D, and that was helpful for determining, these assurances. The DOJ guidance is also very clear that the assurances can be express or they can be implied, but they cover a lot of the examples that courts have now looked to that I mentioned on the prior slide. And here's just a step-by-step from the department's guidance on how to determine if the exemption applies. Next slide. So now we come to competitive harm. And although the Supreme Court jettisoned the national parks competitive harm test, competitive harm is still alive. It's like a zombie theory that will not die. In Justice Breyer's concurring opinion, he tried to resuscitate the competitive harm test from the jump. Some courts have jumped onto that. However, it's really showing its staying power in the continued viability of reverse FOIA lawsuits, and in the FOIA Improvement Acts foreseeable harm standard. So let's jump to the next slide. So before Food Marketing Institute, Exemption 4 was considered mandatory because Exemption 4 overlaps with something called the Trade Secrets Act. And I talked to you earlier about what a trade secret was and how it's a very narrow and difficult to prove category of information. That is true, except the Trade Secrets Act is a criminal statute that applies to a wide swath of information. That is not all necessarily trade secrets. The circuits have generally agreed that the Trade Secrets Act was coextensive with Exemption 4, meaning that if it fell within Exemption 4, it must be withheld under the Trade Secrets Act. And courts applied this even a few times when the voluntary submission test from critical mass was used. And how this would play out is if a agency told a submitter, we're going to release your information, the submitter then could go to court and file a reverse FOIA lawsuit. And under that, they would say that the agency's decision to release this information was arbitrary and capricious and a violation of law. And for that violation of law hook, they would say the information falls within Exemption 4, therefore it is protected by the Trade Secrets Act. Next slide. Now, however, it's not as clear whether the information that is only treated as confidential by the company still falls within the Trade Secrets Act. So the Trade Secrets Act, I quoted the relevant language, it protects information that concerns or relates to trade secrets, processes, operations, style of work or apparatus, or to the identity, confidential statistical data, amount or source of any income, profits, losses, or expenditures of any person, firm, partnership, corporation, or association. So now it's less clear and it's less clear that anything that qualifies under Exemption 4 also qualifies under the Trade Secrets Act. I think it does, and I think I would point to a lot of the cases, the handful of cases predating Food Marketing Institute, where the court took critical mass cases and still allowed a reverse FOIA lawsuit. But like I said, that is unresolved. There actually have been very few reverse FOIA lawsuits, and none that have substantially analyzed this issue. So this is a potential a new road, and we're closely monitoring as new, if and when new reverse FOIA lawsuits are applied. But I would think, as best practice, if I were to file a reverse FOIA lawsuit, I would not only say that the information was covered under Exemption 4 based on the Supreme Court's new definition of it, but I would also belt and suspenders it and say it also meets the old definition, which means it falls under the Trade Secrets Act. But that old definition, that's the competitive harm test. So it's still alive. Next slide. The other area where we still see the competitive harm test alive and well is in the FOIA Improvement Act's foreseeable harm standard. So the FOIA Improvement Act is an additional requirement that the agency imposed, the government imposed, Congress imposed rather. And not only does information need to fall within an exemption, but the agency also needs to show that it either, 1, disclosure is prohibited by law, or 2, it would result in the foreseeable harm to an interest protected by the exemption. So I always argue that, information that I'm claiming under Exemption 4, it meets the prohibited by law test because of the Trade Secrets Act. But for the foreseeable harm test, again, I always argue, belt and suspenders. There's somewhat of a circuit split over what is the interest that is protected by Exemption 4. The Second Circuit and one District of Columbia District Court case say that Exemption 4 protects a company's competitive interests. So the foreseeable harm you must demonstrate is a foreseeable competitive harm. One Northern District of California case says that the interest protected by the exemption is confidentiality. And therefore, any disclosure of Exemption 4 information results in a foreseeable harm. That's my position. I think that's the better position, that confidentiality is the harm that's associated. However, again, when I make my submissions, I always argue both competitive harm and confidentiality. Quite frankly, I think this EEO1 FOIA request is going to be a ripe opportunity to litigate this issue about whether it is required and what is the interest, because I think it's very clear that your confidentiality interest is harmed, and I think it's pretty clear that these EEO1 reports fall under the Trade Secrets Act. However, it's a little less clear whether a company or most companies would be competitively harmed if, their diversity demographics were released. There just haven't been a lot of compelling arguments that I've seen on a large scale that broadly apply. All right, here we are in the home stretch. So what does all this mean? What should you be doing to put yourself in the best position to protect your confidential information from a FOIA request? Well, first, create helpful evidence. Update your policies and procedures so it's clear that certain types of information is confidential and employees cannot release it. Update your contract terms with vendors, with third parties, making it clear that any of your company information that they receive that cannot be disclosed, any information that the company thinks is confidential, make sure that that is not available to all employees. Make sure that's only on a need-to-know basis, and have clearly documented processes for how people get approval to join that group that has a need to know. Use NDAs, confidentiality agreements, and also make sure there's annual employee training that at least has a slide or two covering confidential information. You should also monitor company disclosure practices. I can't tell you how many times I have been working with a company and they will say things like, no, we need to protect this supplier list. Our relationship with the supplier is so critical, we can't let the public know about it because they could, our competitors will be able to use that. And then I see a press release touting some joint project they worked on, or companies will tell me that their key personnel, their project manager, we can't disclose his name or her name, and we can't disclose her contact information, yet prominently on the website under who are we, there's her picture with her contact information. And that really undercuts any argument that you think this information is confidential. It's also important that when you get FOIA submitted notification letters that you respond. If you don't respond and let a type of information out one time, it will be more difficult for you to claim that similar information should be protected in the future. I also like to try and manufacture assurances from the government, marking documents with confidentiality, protective legends, even to the point of saying, protected from disclosure, not subject to release under FOIA Exemption 4 of the Trade Secrets Act. Also, pay close attention to an agency's requirements for confidential information. A lot of agencies have processes where you can apply for information to be designated as confidential. It's helpful, especially for very sensitive information, but really for any information that you think is confidential, to take that extra step and be proactive and get that affirmative confidentiality designation. As far as best practices for responding to submitter notification letters, first off, work with the FOIA officer handling the response. A FOIA officer, it's just a tough job. Like they get it coming and going. No one in their agency likes to hear from the FOIA officer asking for documents. He knows he's behind. He knows he has a backlog. He's doing the best he can. So open a dialogue, work with them, request extensions with enough notice. Try to make sure that if you request an extension, you request enough time that you will not need to request a second extension. Do make sure, ask who the requester is. Sometimes that makes a difference. For the contents of the letter, make sure you're hitting all of the elements discussed. And like I said, I always do a belt and suspender approach. I explain why it's exemption 4, and that means customarily and actually kept private, and the assurances of confidentiality, even though that's not required. And then I say, and the FOIA, the FIA standards, it's prohibited by law, and it would hurt confidentiality, and it would hurt my competitive harm. So really hit on every front to give yourself as many outs as possible. Also understand the agency's limitations. A lot of FOIA officers, especially post-pandemic, are part-time, working from home. The systems might not be allowed to receive very large files, so understand that. Ask them if they have a FTP protocol they could use. And everyone's human. Double check the agency's work on the redactions if they give you the chance. Mistakes happen. All right, I think we have about 3 minutes left if anyone has any last minute questions. But I wanted to, in the meantime, I want to thank everyone for, like I said, letting me talk about FOIA. It's one of my absolute favorite things to talk about. And I think it's just such an interesting thing. And right now with the EEO1 FOIA request out there, it's certainly a hot topic of conversation. Well, seeing no additional questions, thank you very much. Have a great day, and feel free to reach out to me if you do have any future FOIA issues or government contractor issues in general. Thank you, everybody.